Okay, so thank you very much for that. And I know that Demetrius and Friedrich both wrote to me to say they won't be here. I'm hoping that we can nevertheless have a good session. If you see me looking away from the camera, is that I have two screens, and I have one screen with the notes and the other one with the camera. Okay, so what I'm going to do is I'm going to share my screen with you. There. Okay, can you see the screen?
Yes.
Okay, awesome. Here's how I propose to proceed. I'm going to be talking to you about WTO dispute settlement, but from a different perspective than normal. And if you have any questions, please don't hesitate. Just raise your hand, and if I don't see your hand, just feel free to jump in. We're going to conduct this very, very informally, and I don't have enough material to sort of cover the full 90 minutes. So I'm hoping that we will have actual engagement with you, with everyone online. What I'm going to do is as I said, take a slightly different approach to the subject of WTO dispute settlement, which is my specialization. Almost everything that you read about dispute settlement in the WTO is concerns itself with the formal procedure. And I think by now you know the basic outlines of the formal procedure. They start with consultations, and then there is a panel process. There used to be an appellate body that isn't functioning anymore. Then after the appeal, there would be a reasonable period of implementation, and this would be subject to arbitration potentially. And then after that, there's an implementation panel to determine whether or not the measure has been brought into compliance. And then there was an appeal of that implementation panel. And then after that, there would be another arbitration potentially on the quantum of retaliatory measures that may be imposed. So you basically have a very, very sophisticated, complex mechanism that on an accelerated time frame that I've been involved in dealing with export subsidies could take about 2 years, and then on a normal time frame it could take a lot more. The Airbus case, the bananas case, the plain packaging cases, these took a very, very long time altogether. So that's that's sort of the very, very brief and 30,000-foot overview of the dispute settlement mechanism of the WTO. Okay, so why is it that we concentrate so much on this formal mechanism? For one thing, the formal procedure at every stage gives rise to an actual report or a decision. We don't call them that in the WTO. They're reports because they're ultimately adopted by the dispute settlement body, which is a political body of the WTO. But for all intents and purposes, they're decisions or rulings. So in all of the different stages that I mentioned, you end up with a report And that report then can be debated, discussed. It's transparent. There are lots and lots of usually comments in the context of the WTO itself, but at the same time there are also comments in academia. So whenever you have a formal report issued by a quasi-judicial instance, it is something that can be tackled with directly. Whereas alternative means of dispute resolution and diplomatic dispute resolution, these are usually confidential. There's almost never a report that comes out of it. So even if everything is going very well, everything is successful, you don't really see those outcomes. So that's one of the major reasons why there is so much concentration on the formal aspects of WTO dispute resolution, as opposed to the potentially informal ways in which most countries resolve their differences. Then, of course, is the fact that whenever you talk about a report, whenever you talk about dispute resolution in its formal sense, you're dealing with a legal text. Legal text, as you know, I'm from a common law. I'm from a common law jurisdiction. I have a common law training, so we're really a lot more used to dealing with judge-made law and judicial rulings. But in the civilian tradition, in civil code countries, and in international law, in most instances, you're dealing with actual text. So a legal text, a treaty text, is determinate. It's there. For members that have to implement it, it provides a measure of predictability, and for observers, for academics and practitioners and diplomats and so on and so forth, the text itself allows analysis, allows engagement, which when you're dealing with alternative dispute resolution and informal dispute resolution is not the case. In diplomatic engagements, when countries meet as diplomatic partners, they talk law, but they also talk interest, and interest is not written down anywhere. Interest is multifarious. It's soft. It changes, and it's very difficult to sort of sink your hooks into it and write about it knowledgeably. It's possible, but it's very difficult. And of course, in the context of each dispute, you end up with different interest factors, and we'll discuss this in a bit. You'll end up with different interest factors that make it very difficult to handle. So in that sense as well, analysis becomes far more challenging than when you're dealing with a legal text, a measure, matching them together, and then potential reports that comes out of that. And finally, of course, we're all lawyers, or we want to be lawyers, and we like procedures, we like text, and so it's a lot easier for us to talk about and write about law and procedures than to talk and write about other matters that are significantly more informal. And as I said, when we get into the realm of interest, that the whole analysis, the shape of the analysis changes. So, as I mentioned, when you have a formal dispute, if everything, absolutely everything goes well, everything goes on time, all stages are functioning, and everybody respects all the timelines, a WTO dispute takes a minimum of 2, possibly 3 years. Okay, and this is not counting any delays and so on and so forth. That's just the way the system functions. Now, I'm now going into areas that are less discussed in academic papers, because they have to do with internal processes of governments rather than the external manifestations of those processes, which are the submissions and engagement in disputes. So when you have a WTO dispute, you have lawyers that go in and make arguments, and then lawyers that are assisting panelists and the appellate body and so on and so forth. Okay, but there is a whole industry behind all of that. You will find out when you go into practice yourself that litigation is about 5%, maybe less, going to court, and the rest of it is just preparation. And when you're dealing with preparation, it isn't just the lawyers who do this. You need a whole phalanx of officials in the background to gather evidence, to analyze economic data, to provide support for the lawyers as they develop the legal arguments. And because you're dealing with governments, you need to constantly, and we'll discuss this, you need to constantly not just prepare the materials, but you also need political decisions at almost every major stage of a dispute. Sometimes when you're dealing with very complex scientific matters or sensitive scientific issues, you'll need scientific experts. The first case that Canada and the EU had was about the labeling of scallops. In itself, probably not it doesn't come across as hugely complex, and yet we had scientific experts on both sides arguing about whether or not a particular species of scallop is one thing or another. And the whole thing turned on eventually on market definitions, but we needed to have the scientists there. And then it gets even more complex when you're dealing with sensitive issues like the hormones case, where you had an entire phalanxes of scientific experts on each side of the engagement, as well as international experts advising the panel. Now, all of this requires resources. If you have one dispute, that's possibly manageable for many countries. The moment you have two, that becomes increasingly challenging. If you have a case that requires interdepartmental coordination, and many cases do, it isn't just your trade department that is managing the dispute, but the environment ministry comes in, the fisheries ministry comes in, the industry ministry comes in, and you need resources in each of these ministries to answer questions that arise in the course of a dispute. And you need mechanisms to coordinate all of this. Okay? So basically, you end up with, you see in WTO dispute, in a WTO dispute that happens in Geneva, you see really only the thinnest layer of the effort that is required by governments in order to mobilize themselves in order to take a case and then manage a case over the life of the dispute. And so the key point I wanna leave with you right now at the outset is, as lawyers and as potential trade lawyers, we tend to concentrate on the sort of the front end of a dispute, going to a dispute, appearing before an appellate body, maybe writing the submissions. When you go to a moot, for example, if any of you has been in a moot, in the Jackson moot, or want to participate, you're given a problematique and you concentrate on developing the absolute best legal argument. That takes a lot of time, huh? But you concentrate on getting the best legal arguments, and then you appear before the judges, you write your submission, you appear before the judges, and you make the argument. But that really is just the thinnest part, the sort of the final bit of the work that needs to be done. And one of the challenges we have as lawyers is the fact that most of the time the other elements of the work, the trade policy, the politicians, the coordination, interdepartmental work, negotiating with Lenda, for example, and so on, none of that is really all that well understood or discussed in the materials, which has a major distorting effect on how we view the institutions of dispute resolution. So I've just alluded to the fact, but now we're going to get into it in more directly. I mentioned politicians. I mentioned government departments. Well, here's the big issue that is left out of most of the analyses of WTO dispute settlement. Interstate disputes are different from private disputes. Okay. Interstate disputes are different from private disputes. Of course, at the heart of every trade dispute is a commercial issue. And you know, we couldn't sell our scallops in France. Canada couldn't sell its scallops in France. That's a commercial problem. But because you're dealing with governments, that commercial issue becomes a trade dispute, or it does not, as we will see, as a result of a confluence of other non-commercial factors. And that's why you need to have the part of the phalanx of trade policy people that end up having to support the case by briefing ministers and so on and so forth. This complexity of trade disputes is made more difficult because, unlike other systems of dispute resolution, unlike every domestic judicial mechanism, the WTO somehow does not have a functioning mediation and conciliation framework. I don't know the law in Germany, but for example, if you have a family dispute, if you have a divorce problem, custody problem in Canada or in Switzerland, before you get to court, you have to go through mediation. It is a required part of the process. And the rationale is not every issue has to end up in court. Courts are public resources, and they have limited capacity. And just simply put, the entire court judicial structure would break down if every single issue went to court. So we begin with, in most domestic systems, we begin with understanding that yes, there are cases that end up in court, but that the system has to have a way of channeling issues that should not be before a judge to informal dispute resolution frameworks. The WTO has something like that in Article 5 of the DSU, but in fact, it's never been invoked and it doesn't function. Simply, there are no modalities for conciliation and mediation. Okay, so I think that is an interesting factor to consider when we're dealing with how it is that interstate disputes end up being interstate commercial problems end up being a dispute, and then you know, in terms of what what alternatives are available to members in addressing those commercial disputes outside of the framework of an actual trade dispute. So here's the premise of the rest of the engagement today, that just like in normal day-to-day life, there are trade problems that, for a variety of reasons, do not give rise to the level of a trade dispute. And the problématique, the challenge, is that the system, the WTO Dispute Settlement mechanism, and all of our engagement with it as lawyers, as academics, concentrates on only one aspect, on only the formal dispute resolution mechanism, and does not address the vast number of other commercial problems that would benefit from non-adversarial resolution. So before I move on, are there any questions? Well, I didn't realize I was that clear, but I'm happy to continue. Please don't hesitate to ask to ask any questions if indeed you have any. Okay, so I'm gonna use a two-country model in order to highlight some of the things that I'm talking about. So you have a Moldavian company that exports widgets into Borduria. And there is a drop in the sale of its widgets into Borduria. Is there a trade problem? Do we have a trade issue here? What do you think? Okay, no takers? Well, the answer is we don't have enough facts. So, I'm going to make a distinction between trade and commercial concerns. I talked about commercial issues in the past, a trade dispute. Now I'm going to make it very concrete. Moldavian product sales into Borduria could drop because Moldavian producers have not adapted to changing markets. What do you know of in the last 20 years? Do you know of a particular product that suffered from this fate? Any takers? Well, I think the best example we have in the last 20 years actually is Nokia. It was a market leader. It had a major presence internationally, and then it simply failed to adapt to the new telephone market, and it basically lost market share and so on. We can also identify other instances where there are commercial issues for loss of market share. Bordurian producers are learning to be competitive. We know that has happened. Third country sales are displacing Moldavian products. This happens as well. Or there is a change in consumer tastes and habits. There's a celebrated case about this in the early days of the GATT, the precursor to the WTO, where Belgium was concerned about the fact that there was that its hat sales were dropping, and the question was that the hats that Belgium produced were no longer in fashion, and there was not a trade issue. There was nothing that any country was doing. It was just that the market wasn't responding to what it was producing. So these are the types of issues that are very clearly commercial issues, and there's nothing governments can do about them. Now, a trade issue is as you see in the three examples that I've given here, a trade issue is qualitatively different. Because what a trade issue is the interposition of a government measure in the market. And we have examples of this. We have live examples of this in the last 5 years. For example, there could be a drop in sales of a product into Borduria as a result of a tariff measure that Borduria has imposed. Again, I'm going to ask to see if any of you knows of a particular tariff measure, of a border measure that is now being discussed all over Europe right now, that is going to have an impact on sales of products into the European Union. Do you know a tariff-based measure that does this? Okay. So CBAM, for example, this is the border adjustment measure for carbon pricing that the EU is trying to put in place. As soon as it's put in place, of course, it makes imported products more expensive, and therefore necessarily results in reduced sales, well, at any rate, in most instances. I mentioned the scallops case in the past between Canada and the US, Canada and the EU, and that case had to do with labeling requirements. A change in labeling requirements resulted in loss of sales by Canadian exports in the French market, and that became that was a French requirement. Eventually, France changed the requirement, and sales of Canadian scallops resumed. But labeling requirements can, in fact, have a major impact on. These are government measures that can have an impact on the market. Or, as the Airbus-Boeing dispute showed, massive domestic subsidization can make products more competitive in the domestic market. So those were issues related to exports of Moldavia into Borduria. But what about Borduria itself? There are instances where Bordurian manufacturers are losing market share to Moldavian imports. Is that a trade problem? And again, we engage in the same sort of discussions. Is the change in the dynamics of the market a result of normal market operations, in which case we're dealing with a pure commercial problem, or is the issue one rather of a government measure, in which case it becomes a trade issue that the two countries will have to address? And we can now expand our analysis from a 2-country model into a 3-country model. You have Moldavia and Subsidania that are importing into Borduria. Moldavian exporters lose market share. And this happens right after Subsidania announces a series of industrial development measures. Is there a trade problem? Again, we ask the question. We try to trace the market impact in Borduria to the subsidies in Subsidania. And if we can trace those, then if we can connect those, then that becomes a trade problem rather than a simple operation of the market. Okay. So
sorry, can I ask you a question? I'm really sorry.
Absolutely.
Hi. My name's Emily. Hi. Just before, with the Subsidania trade problem, does it depend on whether Subsidania is giving subsidies, or it's still government measures that are the development, or even would it be a trade problem even if it's just developing its industries and they're just doing better? That would be a commercial problem, right?
Right. So when we talk about subsidies, subsidies are forms of government intervention in the market. Okay. And so if I could just let me see if I can go back. There you go. So if I can go back here, subsidies are a form of government intervention in the market. Now, if you have, and again, let's take the example of Airbus and Boeing. You have subsidies given to Airbus. That makes Airbus planes more competitive in the market in order to, because their prices are sold, or there's technological development that wouldn't have happened if it weren't because of that. So that's an instance of where a subsidy results in a change in behavior in the market, and that has a direct impact. Now, another problem that I'm working on right now, outside of this, and in fact, this was the conversation I had just before I got onto this call, is in the plastics industry. For example, the argument is that there are a lot of subsidies given to fossil fuels that are an input product into the plastics industry. Now, a lot of the subsidies given in respect of fossil fuels are consumption subsidies. So they're subsidies to reduce the price of diesel or gasoline up to acceptable levels. And we know this happened last year because of COVID. So here's the question. There are subsidies in the sector, but those subsidies, the subsidies given for gasoline, don't have anything to do with the plastics industry. Because plastics uses industrial gas. And so the existence of a subsidy doesn't mean, in a sector broadly defined, doesn't mean that there's going to be a trade issue. But rather what you need to do is you need to connect the subsidy to the particular dynamics of the market. And then that gives you the trade problem. Does that answer your question?
Yeah, thank you.
Okay. Okay, so why do I talk about all of this? It's that, as I mentioned, interstate disputes are different from normal commercial disputes. And there's a whole process involved in making a decision to take a case, to take an issue and turn it into an international trade dispute. The absolute first sort of analysis that needs to be undertaken is what we've just discussed. That is to say, we know there's a problem. Saudi Arabia can't sell its product into Bordeaux. But is that problem a market issue, in which case there's no trade dispute because there is no trade issue? Or is that problem the result of a government measure so can we trace that problem to a government measure? That is the first question that you ask when you do the triage, the analysis that goes into determining whether or not a particular matter should be brought to the WTO. Okay. So this triage, this selection process is the process that every member of the WTO either goes through or at any rate should go through in determining whether or not to bring a trade dispute. And in fact, the WTO agreement itself provides for this very, very clearly. So the first issue is that when you go to the WTO, you need to be able to connect your problem to something a government has done. Because if the government is not involved, it's not a matter for the WTO to deal with. As well, the WTO agreement itself says the object is to find a way to resolve the problem. That is to say, when you decide to go to a dispute, the first question you ask is whether or not there is a dispute. The second question you ask it is, am I likely to get what I want out of this process as a country? And this is why the treaty itself, the WTO agreement, says you need to exercise judgment whether bringing an action under these procedures would be fruitful. So even if you can trace a problem back to a country, even if the issue is really, really important and challenging and so on, nevertheless, you need to ask yourself whether it's worthwhile going through this process in order to address the commercial and trade dispute that you have with the other country. So we go back to our two-country model, and then we try to determine how it is that we engage in the triage exercise. How do we determine whether bringing action under these procedures would be fruitful? This is stuff that we do all the time in the government of Canada. This is the stuff that the European Commission does all the time when it comes to an issue. And in fact, I happen to, I've advised a number of other governments than the government of Canada, and every other government also goes through this type of exercise. So we're talking about a legal dispute. So the first question we ask is this: is what the other government doing Is it legal or is it illegal? Is it consistent with the WTO agreement or is it not? Because if what the other government is doing is consistent with the WTO agreement, there's no point in going to the WTO asking for relief. It doesn't mean that there isn't a problem. It just means that there isn't a problem that can be resolved in the WTO. But making it determination that what they're doing is illegal doesn't end the analysis. Remember, we're dealing with governments, okay? And we're dealing with a legal system. We're dealing with a treaty that binds both us and them. And if we win in a case against another country, and there's a report that says what that country is doing is illegal, and if we're doing the same thing, then we win against them, but we lose against ourselves. Because then there's another country, another member of the WTO that's going to come turn around and take us to the WTO and say, wait a second, you're doing the exact same thing. You won against Borduria, now you have to change your practices. So that's one example where the mere fact that the other side is doing something illegal might not necessarily be determinative of whether you will actually do something about it. Another example is you do an analysis and you find that even that you might win, but on grounds that aren't really favorable to you. We know this. There's a word in it in English. I'm sure there's a word in it in German. A Pyrrhic victory. And this has happened in a number of cases where a member wins a case, but the terms of the victory, of the legal victory, are not favorable to its longer term interests. And then, even if you decide that the measure is illegal and that it's not going to affect your interests, the question remains whether or not the subject matter of a commercial dispute is something that you want to address by a quasi-judicial forum. The subject matter of the problem might be sensitive, might be too sensitive for you, and you might want to contain the sensitivity of it between you and your trading partner. So I'll give you an example. There's another question that you ask is, do we even need to address it? When I was a very young trade lawyer, I was working late with a colleague on a dispute, in fact. And it was the scallops dispute. And one of our policy clients came up. This is an official in a non-legal department of the trade department. Came up and said, "Oh, look, I found this that the European Union is doing." Okay, we looked at it. This was a measure of the Commission in respect of health requirements, inspection requirements of a tropical product. I think it was passion fruit or mangoes. I don't remember which. And I looked at it, and the official said, what the commission is doing is clearly illegal. And I looked at the measure, and it looked like, you know, it was not terribly useful, and didn't look like consistent with one of the agreements of the WTO. But I said, yeah, I mean, it looks like it doesn't really, it's not legal, but I don't remember if Canada exports tropical fruits. We don't. So, I mean, I don't see what I'm not quite sure what the issue is for us. And he said, well, it's the principle of the thing. And we both, this is like 10:30, we're both working on a commercial dispute, you know, an important dispute. And we just looked up and said, we don't do principle here, we do money. We were exaggerating, of course, but the point being that it wasn't enough that another member of the WTO was doing something that we didn't like, or that was inconsistent with the WTO agreement. There had to be a commercial question involved. And so in this sense, the size of a dispute matters a great deal. That of course is always a relative question. For example, Canada brought a case against Japan in respect of alcoholic beverages. The market value of the dispute was about $30 million a year. Now that's not a lot in terms of bilateral trade relations. We actually brought the case because the Americans were ahead of us, and the Europeans. So the EU and the US went ahead because they have billions of exports into Japan. And we joined in because that actually reduces the exposure to Canada of bilateral relations. So that it made sense. They did the bulk of the work. We were there. We provided our support, and you know, the countries ended up winning. There were two other cases, the hormones case and the scallops case, where the value was in the tens of millions, like basically 10 million, I think, in either case. But in those cases, the economic impact was highly concentrated. Beef in Alberta, and the scallops case in literally two villages in the Atlantic coast. So when the economic impact is concentrated, then as I said, you look at the size of a dispute in relative numbers. Other than that, the big ones, softwood, you're looking at $1 billion a year, $1 billion a year in tariffs. In the dairy case, for example, we were defending, but we were looking at an $8 billion market, protecting an $8 billion market. In the aircraft subsidies case, which again I argued, we ended up with about $1.5 billion in damages. So these are significant numbers, and you can see why when you're dealing with those numbers, you would accept taking a case for several years. But if the numbers are lower, and if they're not concentrated, then obviously there's less incentive for a government to launch a trade dispute. The cost and length of a trade dispute has increased. I mean, in the Airbus, Boeing, the two cases cost the governments and the industry tens of millions of dollars. Softwood and the aircraft sector cases between Canada and the US, and Canada and Brazil, it's the same thing. Just to put things in perspective, in the plain packaging case, which was between Caribbean tobacco producers and exporters and Australia, Each hearing in Geneva cost the Australian government $100,000 just in travel fees, because they have a delegation, and they have to send the delegation from Australia to Geneva. It's a 23-hour flight that has to be. It's a business flight. Even if you just reduce and trim the expenses, just the cost of coming here for the entire delegation was, as I said, about 100,000. And then a typical case has about 3 or 4 meetings. And then on top of that, you add the cost of lawyers and experts and so on. Okay? And then you have to balance that against so whatever case you're dealing with, you have to balance that against other cases that are in the pipeline potentially, and the other cases that you're running. And trade ministries don't have endless budgets. So that's just the cost, the cost of the outlay, the budgetary outlay of a dispute. And then you deal with capacity. Do you have enough officials, enough experts to commit to a dispute for 3 years? Do you have enough lawyers, or do you need to retain a law firm? Do you have the domestic experts, the internal experts, to deal with the fisheries issue, to deal with the with a health issue? Is your industry strong enough to bear some of this cost? It's not a given. Some industries that appear big from the outside run on incredibly thin margins. I know I have some in the clients that are in that situation. The numbers are impressive, but the actual profit margin is low, and so it would be very difficult for them to support funding. It would be very difficult for them to support funding for the case itself, or to provide experts. The list goes on. Political considerations are important in interstate disputes. When Canada brought its case against Brazil, the president of Brazil called the prime minister of Canada and asked for a period of reflection. He said, this is really, really sensitive in Brazil, and it could have an impact on Canada-Brazil relations. Some cases are politically sensitive, but they don't harm relations. Softwood lumber between Canada and the US. We've had a dispute that predates Canada's existence as a country. Every year, we spend tens of millions on that dispute. It doesn't affect our bilateral relations, but it is disruptive. If you're in the middle of, and then we come into diplomatic considerations, just in terms of political impact, domestic political considerations also have an impact. The more concentrated a particular problem is, the more politically sensitive it's going to be. Diplomatic considerations, relations with countries. Institutional considerations. When we take a case against another country in the WTO, do we have allies, or are we going to be isolated? And as I mentioned, sometimes winning a case could end up being a Pyrrhic victory. And then, at the end of the day, if you win, what do you win? These are EC hormones and US gambling are two of the most high-profile cases in the WTO. In neither case did the country involved implement the findings, and so retaliatory measures were imposed in EC hormones, and in US gambling, nothing happened. So when you look at the distribution of disputes, something interesting and entirely predictable emerges, which is that the countries most involved in international trade are the countries most involved in international disputes. And but, and this is a key point, you look at the numbers and then you match them against the actual flow of trade, and that in itself becomes interesting, because you have $28 trillion of trade annually each year among members of the WTO. And the most number of disputes you've had is about 30. 28 trillion, 30 disputes. I don't think there are only 30 problems in the world, in the world of trade. Those are the 30 that got through the triage process, that got through all of these considerations. And the big users are these countries. The rest of the membership, developing countries and some developed countries have done one or two cases. The least developed countries have done no cases whatsoever. And we have numbers to indicate exactly what's going on. So these are numbers from the committees on trade barriers to trade, technical barriers to trade, and sanitary and phytosanitary measures. So technical barriers to trade are things like technical regulations or labeling requirements. That's one example. And SPS measures are measures like the hormones measure, where the US is not happy, the EU is not happy with how the US produces beef. There are concerns about residues of artificial hormones, and so the EU imposes an import ban on the product. So here, the numbers are interesting, because there have been, as you can see, about 80,000 notifications to the WTO. So 80,000 technical measures and SPS measures have been notified to the WTO in the last 20 years, 25 years. Of those, members have raised concerns about 1,300 of them. So that the good story is, by and large, members are doing something right. Because of the 80,000 measures, there have been only 1,300 issues that have been raised. These are specific trade concerns. Of those 1,300, 110 are the subject of consultations, which is the first level of a trade dispute, and only 23 have gone to a dispute. 80,000, 23. 28 trillion, 30. Not quite the same, but you get the picture. There's a lot of trade going on. There are a lot of issues, but only very few, a fraction, end up in a formal dispute. For all the reasons that we've just discussed. So the key point here is, take those 1,300, that 1,300 as issues that are raised. These are specific trade concerns. So members have identified these as measures that have an impact on their interest. And of those, only 110, so less than 10%, end up being taken further in the formal dispute. 90% linger. They're still there. They haven't been resolved. And this is where, in the last few minutes, in the last bit that I have, this is where I'd like to talk to you about alternatives to formal dispute resolution. Again, we come back to this. Formal dispute resolution starts at the consultation level. Here, you have 110 out of 1,300 where there's a dispute, and of those, 23, so about 20% end up delivering a judicial result. And in the first instance, this bit, this delta, the 90% isn't being taken care of, and it is not clear what happens to this delta, but we're not going to discuss that. This is what we're concerned about. So there have been attempts at addressing these numbers in the committee structure of the WTO. So there are two technical, so we talked about special trade concerns. There are two technical committees: technical barriers to trade and sanitary phytosanitary measures. And there is a process to raise them in committee. Okay, so here's a challenge. This process hasn't been used a lot. Maybe five times. Go back. You have here 1,300 specific trade concerns. You have committee structures in place, but they're not being used. I think the reason is that a committee structure is not always the best place to resolve bilateral problems. Think about yourself. Each and every one of you has been in a work situation. Maybe you deal with NGOs. Maybe you've launched an NGO yourself. Maybe in the university, you're in a committee setting. When I was in university, the 8 years I spent at the University of Toronto, I was a member of dozens of committees, both at the university level and at the student level, organizing this, that, and the other. Think about your own family framework. Is it the case that you can resolve disputes all the time? Is it the case that you can resolve disputes by bringing them up to the bigger group? Sometimes it helps, but not always. The transparency itself becomes a problem, because sometimes you don't necessarily want to air your dirty laundry in public. So the process is there, but it isn't being used. And it isn't being used because the process is not necessarily fit to address the issues that are brought up. Doesn't allow, in a very real sense, doesn't always allow a graceful exit to the country that's at the receiving end of the process. There is in the dispute settlement understanding, there's provision made for arbitration outside of the formal framework that I told you about. So arbitration technically takes less time because it's only one stage, but it still requires lawyers, and it's still litigation. And you know, in your own experience, that as soon as you go to court, as soon as you formalize a dispute, you affect the relationship. So arbitration, it doesn't take as long, but it also doesn't provide the comfort that that a formal dispute resolution mechanism provides to the defending member, which also explains why it's been used only once or twice, and now the mechanism is being used as a makeshift appeal. But arbitration as a first instance dispute resolution mechanism hasn't been used. Then you have Article 5 of the, I mentioned this in the past, and when I started, but you have Article 5 of the dispute resolution mechanism, of the dispute resolution understanding, dispute settlement understanding. And so this is from the early days of the WTO. It has never been formally invoked. It has elements of it have been used. Good offices, mediation, in the bananas case, in the most recent case, between Philippines and Thailand. But the key issue here is that, first of all, the procedure itself may be launched only after consultations have been requested. So if we go back to this model, Article 5 as a mechanism is not available for this bit, the biggest area of areas of commercial problems and trade problems. You need to launch a dispute first, and once you've launched it, then it's available. But here, Article 5 is not available. And then there's mention of good offices, conciliation, mediation, but they're not really defined. The modalities aren't there. The procedure isn't there. How long will mediation take? What is involved with conciliation? What's the difference between good offices and conciliation? And then, of course, there's the fact that as soon as Article 5 is invoked, the dispute settlement process grinds to a halt. So if you're exercising this in the middle of a dispute, you have to suspend the dispute, which is challenging for members to do. So it was really in response to all of these challenges, and in the light of the fact that the dispute settlement mechanism of the WTO is no longer fully functioning, and also in the light of the fact that for least developed members, the WTO dispute settlement mechanism has never been fully functioning. There's never been a dispute launched by a less developed member. I thought, okay, well, this is the time to rethink everything. This is the time to actually go back to the drawing board and ask oneself, what is the point of all of this? What are we trying to do? And then address that. So what we're trying to do is not to come up with a judicial reason. That is not the ultimate objective. The ultimate objective of dispute resolution is literally that, resolving the dispute. So you take the biggest number of disputes that we've already discussed, you look at their profile and you say, there's a reason why these disputes are not in a formal mechanism. The number isn't high, they're too technical, they're not politically sensitive enough, or they're too politically sensitive, they're diplomatic considerations. You name the problem. And ask yourself, what is the best framework within which we can address these concerns? So then you go back to the drawing board and you start with concepts you already have. There's no point in reinventing everything. You look at conciliation and mediation. What do they mean? Well, the WTO agreement doesn't provide a definition. But we know what they mean in domestic law. And we know what they mean in other international organizations. By the way, I've done a major paper on this very issue for the GATE-SET, the German Development Agency. If you Google STTI complaints, the webpage comes up, and it's a 70-page report long, but I go through all the different modalities. There are all kinds of different ways that alternative dispute resolution, non-adversarial dispute resolution is structured in different countries, in different settings. But at a basic level, we need to figure out what conciliation mediation mean. In some national levels, conciliation is expert-driven. Mediation is basically facilitated diplomacy. These aren't definitions that are written. They're not written in stone. But at an early stage, at some point in the WTO, we need to come to agreement on what they mean. Then what is the point of having a conciliator or mediator? I've had this conversation with colleagues here. Former members of the appellate body, these are former judges, quote unquote, of the Court of Appeal of International Law. They believe that in every instance, the issue has to be resolution of an underlying legal dispute. And of course, that is not what mediation and conciliation is all about. Mediation and conciliation is primarily about resolving an underlying commercial dispute, not assigning winners and losers in a legal battle, but coming up with a win-win solution for both parties. And in this respect, I highly commend to you, if you have the time, if you're interested in the subject matter, to look at the Timor-Leste Conciliation Commission report. This is the dispute between Timor-Leste and Australia on a maritime boundary. It's if you're interested in international law, it's really the place to start. So the case, there was a case before the court, and the two parties decided to use the Conciliation Commission in order to avoid litigating the case. They nevertheless submitted hundreds of pages of submissions to the Conciliation Commission about their respective legal position. And the response of the Conciliation Commission was phenomenal. In one sentence, two maybe, it addressed all the legal questions. It basically said, thank you very much for putting forward all of your legal issues, but of course, the Conciliation Commission will act within international law. That goes without saying. It derives its mandate from international law, from the treaty. It has to function within the treaty. But then it says, those are not the issues that are before us. The point of conciliation is not to assign winners and losers in a legal context. The point of conciliation is to operate within the law, but to try to come up with a resolution that is acceptable to both parties, so that they both go away, having a paper in hand that says, you got something. We then, an issue that comes up is confidential, the confidentiality of most mediation and conciliation frameworks. Now, obviously in the Timor-Leste conciliation, that was not confidential, but most conciliations are confidential. And here's the thing. We, as academics and lawyers and trade lawyers and diplomats, we all love everything to be transparent. we use, I mean, I'm using the Timor-Leste Conciliation Commission report as an aid. But more importantly, all of these things are there. We use them to write papers and get published and get tenure. But is that really the best way for a dispute to be resolved? Not necessarily. No diplomatic engagement is ever publicized on trade matters. They happen behind closed doors. Some engagements within the context of a treaty, for example, under the Canada-EU CETA, committee meetings, their minutes are available. But by and large, when our ambassador goes in to meet, commission officials in Brussels, or the EU officials going to meet officials in Ottawa, there are no minutes published. And a lot of problems are resolved in those private interactions. There's nothing inherently wrong in those kinds of diplomatic engagements if they help, if they're obviously done within the context of the law and they help resolve a dispute. There are some challenges to informal procedures because of concerns about rule of law and power politics. I mentioned the case of US gambling, and it's always presented as that was a case where little Antigua took the US to the WTO and won. And won the right to impose $23.1 million in retaliation rights. Okay, it won, but then what? Did it impose the retaliation? Of course not. It's going to shut down its own economy if it does that. And so it seems to me that the real question is not rule of law versus power politics. It's to acknowledge that economic relations invariably turn on strategic and economic imbalances, and the way to deal with them is not to simply channel them through courts and expect that something magic will come out of it at the end of the day, but rather internationally to find the best solution that can blunt the impact of the imbalance. I talked about how long it takes to run a case and how much effort it takes to run a case, and this is a critical point. One reason why less developed countries have not brought cases is that the economic interests are not big enough to merit a dispute for 3 years. But also part of it is that even countries like Canada sometimes suffer from not having enough people to run cases. And the same is true for developing and less developed countries. They don't have huge government ministries, and they don't have the expertise to run the cases. And so when we devise a mechanism, we should devise it in a way that addresses those concerns, not some abstract vision we have of what a judicial mechanism should look like. We've looked at, I mentioned retaliation, and that's what is meant by enforcement. But of course, that's a suboptimal measure. The US and the EU, each of them won billions in retaliation rights in the Airbus case. Not a single cent of a subsidy was removed, and the end result was that a lot of champagne and cognac ended up being more expensive in the US. Again, that between the US and the EU, that's fine. But how that works when you're dealing with Antigua and the US, that's a different issue. And finally, rules of procedure. We talk about legal procedures. We don't always talk about their complexity and the impact of that complexity on conducting a case. I've heard a lot about streamlining procedures to help developing and less developed countries. Whenever I ask about streamlining, it sounds good, huh? It sounds exceptionally with it, advanced. Streamline. Very progressive. Streamline to help poor countries. Great. Exactly what are you going to streamline? Reduce the hour, the time required to submit to make a submission. Well, reducing time frames is more problematic for developing countries because they don't have the resources already. So you're asking them to do with the resources they don't have to do things in a shorter time frame. So that doesn't really help. Have fewer meetings, but what about the rights of a country to defend itself? Relax evidentiary rules. Again, what about the right of a country to defend itself? The rules of procedures are there for very specific and good reasons. And relaxing them has consequences. So anyway, that's where I am. You can look up my paper on mediation and conciliation on my website. It's right behind me. You can look it up and just to see exactly what I'm proposing. But fundamentally, I think we need to find a different way of addressing the kinds of disputes that members have to deal with. I'm going to stop there. I've got 4 minutes left. So if there are any questions, let me know, and I'll try to address them in the time that remains.
Hi, may I ask you a question, please?
Absolutely.
I was just thinking about what you're saying about there needing to be solutions for poorer countries to enter this process. And I'd read about the International Advisory Center that's set up but this is an investor state dispute resolution. Well, it's being set up, I believe, that it's an attempt to be made. What do you think about that? Do you think that's a sustainable solution? And where would the funding come from?
Right. Well, governments will, developed countries will always find money to help developing countries. The funding is not the biggest issue. The mechanism is and what it tries to do. So there is an advisory center on WTO law that developed countries set up 20 years ago, 23 years ago, in fact. It's based in Geneva. It's meant to help developing and less developed countries on WTO law. It provides a great deal of advisory services. It represents developing countries in litigation. It has been very active in litigation. At the same time, and not a single less developed country has ever brought a case, even with the ACWL there. And that's because the issues are, as I mentioned, the issues are fundamentally internal to less developed countries and internal to the processes of litigation. So having the advisory center helps. It helped India and Indonesia and Philippines and Thailand, and Tunisia in the case against Morocco. That's not in itself a solution. On the investor state side, I don't know about what it's being set up to do. But I think the dynamics of investor state disputes are quite different because you're dealing with a private challenge against a state measure and not a state-to-state dispute. So I can't comment on the investment side, but certainly on the trade side, the ACWL has had some success, but not at all in the key areas where 20 years ago when we were setting it up, we thought it would help. And it's because it's essentially addressing a problem, litigation, that is outside the resources of most less developed countries. So it's the process that's the issue, not the kind of support that we provide into it.
Thank you very much. And if I may, if no one else has a question, I also wanted to ask about, well, I guess policy concerns, because in many of these disputes, it seems like states are going after other states for changes in their legislation, which are normally for a social policy. And I wonder if that's ever a consideration and how it could be, because I believe a lot of this is based in trade agreements that are made a long time ago in a post-colonial time. But not only are they really hard to get out of, but they have really long sunset clauses, I believe. So how can we adapt to this process to the needs of climate change and the needs of more progressive legislation?
Well, I'm not quite sure what you mean by sunset clauses. There is I've written extensively on the subject, so and I've negotiated multilateral environmental agreements. There is absolutely nothing in terms of social or environmental policy that members would want to do, members of the WTO would want to do, that the WTO itself cannot accommodate. The WTO agreement as a whole is written, is drafted, is negotiated by countries that even 25 years ago, when it was drafted, they were negotiated. They were very conscious of their prerogatives in terms of protecting the environment and so on. And it has undergone progressive development through jurisprudence over the last 20 years. Whenever you hit a problem that appears as if the WTO is saying, oh, you can't address this environmental problem, go read the case carefully. Because to the extent that it says it, it basically doesn't say you can't address it. It just says this particular means that you have chosen is not the kind of thing that that either would address the problem, or in most instances is not the kind of thing that actually is even-handed relative to the interests of other members. But by and large, I cannot think of a single truly environmental measure that has been brought to the WTO that the WTO has said you can't do it. That just the objectives. None of the objectives are perfectly attainable within the context of the WTO. You really do have to dig into the details. On that topic, I would love to engage more on this, but anyway, you have my contact details. If you have any questions, feel free to engage. I'm gonna stop right here. And wish you all the best.
Thank you. Bye.
Bye-bye.
Thank you.
Bye-bye. Thank you.
As I said, feel free to get in touch if you have any questions.